Thank you all for joining us today for today's paid family leave webinar for employers and HR professionals. I'm Adam Rossi from the Communication and Outreach Unit here at the Workers' Compensation Board. Joining me today is Courtney Valley from our Office of General Counsel, and she will be on hand to answer any questions you have today. So today we are going to provide you with an overview of New York's paid family leave benefit, including contribution and benefit rates for 2023 and some updates for 2024. Information about COVID-19, as well as some resources to help you share information with your employees. We will be using the chat feature to take your questions today. You can enter your questions at any point during the presentation today in the chat box. If you look on the bottom right-hand side of your screen, there should be a little chat bubble icon. Just click on that and the chat box will pop right up. Again, any point today you have a question, feel free to type it in there, but we are going to hold off until the end of the presentation to answer any questions you have. Courtney will answer as many of your questions as she can, but if you have questions that we either don't get to today, or if you think of something after the session ends, again, we will be providing you with resources at the end of the presentation. Also, when you signed in today, your name and email were given to us, so we do have your email address on record. However, if you have a specific question or a topic you'd like to discuss more deeply with the board or with Courtney regarding PFL, please be sure to share that topic and question in the chat box along with some contact information so we can follow up with you. The chat settings are set so that only panelists can see the questions or comments that come in. So right now, only Courtney and I can see questions coming in. So you don't have to worry about others seeing your personal information. And again, we do have your email on file. So if you need us to reach you, we can reach you via email. But if you'd rather have us contact you by phone, or if you just want to make sure we have the correct email address, just feel free to type in your name with your email address or contact number with your question, and we can make sure someone will follow up with you. So with that, let's go ahead and get started. And as I mentioned, today we are going to be reviewing some important information with you regarding New York's paid family leave. As employers and HR professionals, you play a critical role in the paid family leave process and in helping employees navigate this important benefit. So today, we will be providing a brief refresher on New York's paid family leave and how it works. We will review 2023 benefit and contribution information and go over what's coming in 2024. We will review who is eligible for paid family leave, review key responsibilities as an employer or HR professional, go over some similarities and differences between paid family leave and FMLA, discuss New York State's COVID-19 quarantine leave, and then highlight the many resources that are available to you. We're going to start with a little bit of background. In April of 2016, New York paid family leave, which is the nation's strongest and most comprehensive paid family leave policy, was signed into law. Paid family leave is employee-funded insurance that helps employees be there for their family when they're most needed. Because of paid family leave, workers across New York no longer have to choose between caring for their loved ones and their jobs, as we now have employee-paid insurance to help in these critical times. New York's paid family leave provides you with a structure to help your employees care for their families in times of need. Paid leave has been shown to increase workplace morale and employee retention. Fully funded by employee contributions, New York State's paid family leave provides job-protected paid time off to employees who need time away from work to bond with a newly born, adopted, or fostered child, care for a family member with a serious health condition, or assist loved ones when a family member is deployed abroad on active military service. Under legislation signed into law in March of 2020, paid family leave also provides paid time off and job protection so employees can care for themselves or their minor dependent child when under a mandatory order of quarantine or isolation due to COVID-19. We'll go over these details in a little bit later in the presentation. They are a bit different from the others. In addition to paid time off, New York's paid family leave also has strong employee protections. Employees are guaranteed to return to the same or a comparable job after taking paid family leave. Comparable job is defined as a position with comparable employment benefits, pay, and other terms and conditions of employment. Employees are guaranteed continuation of health insurance on the same terms as if they had continued to work while out on paid family leave. If employees contribute to the cost of their health insurance, they must continue paying their portion of the premium while on leave. Employees are also guaranteed protection from discrimination and retaliation. Requesting or taking paid family leave cannot be held against them. As an employer or HR professional, it may be helpful for you to know the kinds of questions employees are asking, which could then help direct the guidance you provide and make the materials you make available. These questions on your screen here, these are the top questions to the PFL helpline from employees, and we will cover the answers to all of these throughout today's presentation. First, though, let's walk through a quick review of the 3 basic uses of paid family leave. We'll start with bonding with a child. Paid family leave provides both parents time off to bond with a new child within the first 12 months of the birth, adoption, or foster placement of the child. Parents who work for different employers can take paid family leave at the same time to bond with the same child. Parents who work for the same employer can take it at the same time unless their employer prohibits it. In that case, they can take leave separately over the first 12 months following the child's birth, adoption, or foster placement. It is important to note that expectant parents cannot take paid family leave for their own pregnancy. They can take it after the baby is born because paid family leave is used to care for someone else, but they cannot take it for their own pregnancy because it is not to be used to take care of themselves. And we will go over that in a little bit too, in reference to FMLA. A parent may be able to take paid family leave before the actual adoption or placement of a child if an absence from work is required for the adoption or placement to be finalized. Paid family leave is also available for employees to care for a spouse, domestic partner, child or stepchild, sibling, parent or step-parent, parent-in-law, grandparent, or grandchild who has a serious health condition. Siblings are new to this group of eligible family members as of this year. The exact effective date was tied to your paid family leave policy renewal. So if you're not sure, just check with your employer to see when that took place for your policy. A few other important notes for family care. Domestic partner is defined broadly under the paid family leave law. It includes people who are not related by blood in a manner that would bar marriage in New York State and are dependent on one another for support. So, for example, an employee may be able to prove that they are in a domestic partnership by showing that they own property together or if they have children in common. A legal relationship is not necessary. Also, it doesn't matter if these family members live outside of New York or even outside of the country. Employees can take paid family leave to care for their family member as long as they are within close and continuing proximity. So in other words, present at the same location as the family member they're caring for during the majority of that PFL period. This may include necessary physical care, emotional support, visitation, assistance in treatment, transportation, arranging and a change of care, assistance with daily living matters, and personal attendance services. In order to take this type of leave, the employee's family member must have a serious health condition. A serious health condition is defined as an illness, injury, or condition that requires either inpatient care in a hospital, hospice, or residential facility, or continuing treatment or supervision by a healthcare provider. The third type of leave is for assisting during a military deployment. Paid family leave benefits are available when a family member is deployed abroad on active military service or who has been notified of an impending call or order of active service abroad and assistance is needed. Reasons for paid family leave for an active service deployment are the same as the military provisions of the Federal Family Medical Leave Act, otherwise known as FMLA, and they cover the employee's spouse, domestic partner, child, or parent. There are a number of instances where paid family leave here will help, which we have typed out here on your screen. If you want to take a look at those, jot them down. And as we mentioned, there are also 2 uses of paid family leave related to COVID-19, which we will cover in a few minutes. For now, though, let's take a look at the program benefits and contributions for 2023. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2023, the New York State average weekly wage is $1,688.19. That means the maximum weekly benefit for 2023 is $1,131.08. This is $62.72 more than the maximum weekly benefit for 2022. It is important to note that employees can take this paid time off all at once or intermittently. However, it must be taken in full day increments. Paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually and is subject to change by the New York State Department of Financial Services. In 2023, the payroll contribution is 0.455% of an employee's gross wages each pay period. The maximum annual contribution for 2023 is $399.43, and this is $24.28 less than in 2022. Employees earning less than the current New York State average weekly wage of $1,688.19 will contribute less than the annual cap of $399.43, consistent with their actual wages. But we are close to the end of the year, which means 2024 is upon us, and we now have updated totals. So the New York State Department of Financial Services recently announced the paid family leave updates for 2024. Beginning on January 1st of 2024, the maximum weekly benefit will now increase from $1,131.08 to $1,151.16. Meanwhile, employee payroll contribution rates will be decreasing to 0.373% of an employee's gross wages each pay period, capped at an annual maximum of $333.25. And again, if an employee earns less than the New York State average weekly wage, which come 2024 will be $1,718.15, their annual contribution will be less than the cap. And employers, you may start deducting at this new rate, again, starting January 1st of 2024. So now that we've covered the types of leave, the benefits, and the costs, let's now review who is eligible to take paid family leave. Most private employers with 1 or more employees are required to have paid family leave insurance for their employees. Public employers may opt into the program, and employees of public employers who are represented by a union may be covered if paid family leave is collectively bargained. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for the amount of time employees have worked for their employer. Full-time employees, including domestic workers, who regularly work 20 or more hours per week are eligible for PFL after 26 consecutive weeks of employment with the same employer. Part-time employees who work a regular schedule of less than 20 hours per week are eligible after working 175 days, which do not need to be consecutive. Citizenship and or immigration status is not a factor in employee eligibility. Paid family leave coverage is not optional for eligible employees. However, employees can waive coverage if they regularly work fewer than 20 hours per week and won't work 175 days in a year, or if they regularly work 20 or more hours per week, but won't be in employment with that employer for 26 consecutive weeks. Seasonal workers are a good example of this since they may work full-time, but they'll only be working for 3 months out of the year. If an employee meets the criteria for waiving coverage, the employer must provide them with a waiver form, which is available on our website at paidfamilyleave.ny.gov. You can see the link on your screen there, /PFL-waiver-form. And employees who properly file a waiver will not make contributions and will not be eligible for paid family leave benefits. Employers should keep a copy of an employee's waiver on file. If an employee's schedule changes, such that they no longer qualify for a waiver, that waiver will be automatically revoked within 8 weeks of the schedule change. An employee can also voluntarily revoke a waiver at any time. If an employee's waiver is revoked, their employer will begin taking paid family leave contributions and collect any retroactive amounts due. Keep in mind, however, that any amounts collected in excess of the paid family leave premium charged by your carrier must promptly be returned to the employee. Now let's review how employees can request paid family leave and the employer's role in the process. So here's how the PFL request process works. Before applying, the employee must notify the employer at least 30 days before their leave will start if it's foreseeable. Otherwise, they must notify their employer as soon as possible. Next, the employee will obtain the request form package for the type of leave they need to take and complete the request for paid family leave, which is Form PFL-1, and they will follow the instructions on the cover sheet. They'll make a copy for their records and then submit it to their employer. You, as the employer, must fill out their section of the form and return it to the employee within 3 business days. The information includes items such as the employer's address, FEIN, the employee's date of hire, and their last 8 weeks of wages. If the employer does not complete their portion of the form, the employee can still submit the form and cannot be denied solely based on the employer not filling in their portion. Employees will submit Form PFL-1, the other request form specific to the leave they're taking, and any supporting documentation directly to the employer's PFL insurance carrier. They can submit their request before or within 30 days after the start of their leave before they risk losing benefits. In most cases, the insurance carrier must pay or deny the benefits within 18 days of receiving the completed request package or the employee's first day of leave, whichever is later. Employees can get paid family leave request forms from their employer's insurance carrier, or directly at paidfamilyleave.ny.gov/forms. If for some reason an employee's paid family leave request is denied, or if they have another claim-related dispute, such as the amount of benefits or timeliness of an insurer's decision, they may request to have the decision reviewed by a neutral arbitrator. The insurer, or if self-insured, the employer, will notify the employee of the reason for denial and provide them with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, the National Arbitration and Mediation, and more information can be found on NAM's website, which you can see there on your screen. As mentioned earlier, an employer may not discriminate against an employee for requesting or taking paid family leave, and an employee is guaranteed job protection with the same or a comparable job upon return from paid family leave. If an employer does not return an employee to the same or a comparable job, terminates the employee, reduces the employee's pay and or benefits, or disciplines the employee in any way as a result of the employee requesting or taking paid family leave, the employee can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate an employee, pay any lost wages, pay attorney's fees, and pay up to $500 in penalties. The process and forms are available at paidfamilyleave.ny.gov, or employees can call the Paid Family Leave Helpline for assistance at 844-337-6303. Paid family leave was designed to be easy for workers and employers, so I'll now walk you through a checklist of employer responsibilities. As we mentioned before, most private employers in New York State must have paid family leave insurance. Now, to get this insurance, the first step is to ensure the coverage is in place. Generally, if employers are required to carry disability insurance, they're also required to carry paid family leave. This insurance is generally added to an existing disability insurance policy. Employers who are self-insured for disability must purchase a separate paid family leave policy or apply to the New York State Workers' Compensation Board to self-insure. For a list of insurers offering paid family leave policies, you can go to the Department of Financial Services website, and they have a paid family leave section. You would go to dfs.ny.gov/PFL. Courtney, could you post that link in the chat? Because I don't think we have it on the screen here. Again, that's dfs.ny.gov/PFL. The next step would be to inform the employees. So employee handbooks and or other written guidance to employees must be updated to include information on paid family leave. To make this easy for employers, we have posted model language on the employer section of our PFL website. Again, that's paidfamilyleave.ny.gov. Employers can customize it or just fill in a few blanks and print it as is. Step 3 is to collect payroll contributions. Employers can withhold at the 2023 contribution rate until January 1st of 2024, at which time they may begin withholding at the new rate that we mentioned earlier. You want to offer waivers to employees who qualify for one, and employers should identify any employees who qualify for a waiver. These are employees who regularly work fewer than 20 hours per week and won't work 175 days in a year, or who regularly work 20 or more hours per week, but won't be in employment for 26 consecutive weeks. If an employee meets the criteria for waiving coverage, the employer must provide them with the waiver form. As we shared earlier, if an employee waives the coverage, they will not make contributions and will not be eligible for PFL benefits. And employers should keep a copy of this employee's waiver on file. Next, you want to post an employee notice. Insurance carriers do provide employers with a notice of compliance, known as Form PFL 120. And it's also known as a notice to employees, where it states that they have paid family leave insurance and they provide employees key information about the benefit. Self-insured employers can get this notice by contacting the Workers' Compensation Board at certificates@wcb.ny.gov. Employers must post and maintain this notice in plain view, similar to how the signage for workers' compensation and disability insurance is also displayed. Employers who receive a paid family leave claim must complete the employer section, Part B, of the request for paid family leave, again, Form PFL-1, and return it within 3 business days. The employer will be asked to provide the employee's last 8 weeks of gross wages and calculate the average weekly wage. Employers should be sure to discuss any specific leave tracking or other processes with their paid family leave insurer. All right, so we are frequently asked about the similarities and differences between paid family leave and FMLA, so let's take a minute to review those. There are several similarities between New York's paid family leave and the Federal Family Medical and Leave Act. Both provide leave for bonding with a child, caring for a family member with a serious health condition, and assisting when a loved one is deployed abroad on active military service. Employees are also guaranteed that they'll return to the same or a comparable position and that their health insurance will continue on the same terms as if the employee had continued to work. If employees contribute to the cost of their health insurance, they must continue to pay their portion of the premium while on leave. However, there are a number of key differences. First being that PFL is paid, whereas FMLA is not paid. Also, all private employers will carry PFL insurance. FMLA does not include insurance, and it has a 50-employee threshold for eligibility. The length of time an employee must work is also different. For PFL, an employee who regularly works 20 or more hours a week must be in employment for 26 consecutive weeks for that employer, and an employee who regularly works fewer than 20 hours per week must work 175 days for the same employer, which do not need to be consecutive. For FMLA, employees must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. One of the biggest distinctions that I mentioned earlier is that under PFL, an employee takes leave to care for someone else, not their own health condition. For FMLA, employees are allowed to take leave for their own health condition. PFL is only taken in full day increments, whereas FMLA may be taken hourly. And lastly, under PFL, employees do not need to use other paid time off first. As we mentioned earlier, there are 2 additional uses of paid family leave that took effect in 2020 under emergency legislation enacted in response to the COVID-19 pandemic. Now, even though the pandemic state of the emergency has ended, the legislation cited no end date. So these laws are still in effect, so we just want to make you aware of them. Depending on the size and type of the employer, the legislation provides benefits for either paid sick leave or a combination of New York paid family leave and disability benefits if an employee is under an order of mandatory or precautionary quarantine or isolation due to COVID-19. This is the only time employees may receive paid family leave and disability benefits at the same time. It also gives employees access to paid family leave if their minor dependent child is under an order of mandatory or precautionary quarantine or isolation due to COVID-19, up to a maximum weekly benefit of $840.70. More detailed information about this for taking paid family leave for personal quarantine or for a child can be found at paidfamilyleave.ny.gov/COVID-19. The page also includes information about New York State's COVID-19 paid sick leave requirements, some frequently asked questions, application forms, and more. As we continue working closely with employers to ensure successful implementation of paid family leave throughout New York State, we do offer a number of resources to help. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, and information about COVID-19 quarantine leave benefits. There is also a special updates for 2024 webpage that is available at paidfamilyleave.ny.gov/2024. There are a number of employee resources there to help and explain and communicate the benefit and deduction changes. These include an overview of the changes, some FAQs, updated model language for employee materials, an employee notice of paid family leave payroll deduction template, as well as a statement of rights for paid family leave. Employers and employees can also contact the Paid Family Leave Helpline at 844-337-6303 for assistance Monday through Friday from 8:30 a.m. to 4:30 p.m. If you are not already subscribed for email updates on paid family leave, you can subscribe by clicking Get Updates on the paidfamilyleave.ny.gov homepage. Finally, we also want to make you aware of the board's Office of the Advocate for Business. The Office of the Advocate for Business is the liaison between New York's business community and the Workers' Compensation Board, giving employers one place to contact for answers to their workers' compensation questions, as well as any questions employers may have about paid family leave as it relates to your business. You can contact the Office of the Advocate for Business at advocatebusiness@wcb.ny.gov. So we hope you found this presentation helpful. Thank you for the opportunity to discuss New York's landmark paid family leave with you. I'm going to pull up the helpline number and the website on your screen so you can have that for reference if you need to write it down. And at this point, we are going to start taking your questions. We do have some questions that have already come in, and Courtney has been reviewing those. However, if you have any questions and you haven't entered them in the chat box yet, feel free to do so now. We will take a look and answer as many as we can up until 1 o'clock. We do have a number of people asking if the slides will be available to review. The answer to that is yes. We will be providing you with a copy of this slide deck as well as a recorded version of today's webinar. It will be posted on the Paid Family Leave website, and the recording will be posted on our YouTube page. We will let you know when those are available via email, so make sure you are signed up for email notifications. Again, just go to our website, paidfamilyleave.ny.gov, and then select the Get Updates button so that you're notified of all that. It may take a week or two, depending on editing purposes and approvals. So just we will get it up there. So if in the meantime, we do have previously recorded versions of this webinar and other slide decks. They may be a little outdated since we're going into 2024, so we have the new updates, so it won't have the 2024 information. But if you need a review of anything 2023 related, we do have previous versions of this slide deck and recorded versions as well. With that, I am now going to hand it over to Courtney, and we are going to start answering your questions.
All right, thanks, Adam. So I'm just going to start from first and get through as many as we can. So the first question that I see here is, can employees use sick or vacation hours instead of receiving PFL benefits? So there's kind of two things here. An employee does not have to take PFL if they don't want to. Generally speaking, it's up to them whether they want to take PFL and when they want to take PFL. But if we're talking about during PFL, an employer cannot force an employee to use accruals during a period of PFL, but you can offer them the choice, and if they choose to so that they get full wages, they can do that. And then I say a follow-up here, are sick and vacation hours reimbursable to employers? So that's a little bit of a trickier question. It's not explicitly addressed in the law. If you pay full wages to an employee during PFL, you can request reimbursement from your PFL and disability insurance carrier. As far as if they're using accrued time off, that is not as clear, but you can talk to your carrier. Okay, the next question here is, does PFL cover bonding or caring for a child from surrogacy? So bonding leave for PFL allows an employee to bond with their child during the first 12 months following the child's birth or placement for adoption or foster care. So the definition of child includes a biological, adopted, foster son or daughter, stepson or stepdaughter, legal ward, son or daughter of domestic partner, or a person to whom the employee stands in loco parentis. So in a lot of cases, it is their biological child, so it would clearly fit, and I think it fits, under a few of the other definitions of child as well. So likely someone would be eligible in that instance. Okay, next question here. There's a couple follow-ups it looks like here, but the gist of it is, how is the PFL rate determined? So the benefit rate, if someone is taking disability, like if they're getting disability benefits and then the mother goes on PFL right after, is it based on the wages before disability or 8 weeks prior to PFL? So average weekly wage for PFL is calculated using the last 8 weeks the employee worked and received wages prior to the period of PFL. So I see your follow-up question down here talking about the carrier saying it's the 8 weeks before, but I think they're probably using shorthand because a lot of people are taking disability and then going into PFL. So they're just saying it's the before the disability, meaning, but it's the last 8 weeks that the employee worked and received wages prior to PFL. So if they're taking disability and then they take PFL, you're not just going to include the disability benefits as, and that won't be their average week wage. It's going to be the 8 weeks that they worked and received wages prior to the period of PFL. Okay, next question here is, does PFL cover National Guard annual training? So I can't provide legal advice, so I'm not going to be able to say, yes, this person is eligible, no, they're not. But PFL military leave only covers exigencies that arise because the employee's family member that's included in that definition, if they're deployed abroad on active military service or they're notified of an impending call to active service abroad. So it has to be out of the country and it's actually active service. So likely a training would not fall into that. There are some trainings and things like that that would qualify, but again, they have to be deployed abroad on active military service or notified of an impending call or order to active service abroad. Next question here is, if an employee is hired and has a baby before 6 months of employment, are they eligible to take PFL within the 12 months of date of birth? So the qualifying event for PFL for bonding is the entire first year of the child's life or placement for adoption or foster care. PFL can be taken and completed at any time within that 12 months. So if, in your example, if an employee isn't eligible yet for PFL when they give birth, once they become eligible, so the 26 weeks or the 175 days, then they're going to be able to take it as long as it's taken and completed within the 12 months of the date of birth or placement. Okay, next question here is, do you have to take retroactive amounts if you're unsure of whether or not they would be staying in your employment when they started working there? And I think that this came in during the waiver section. We're talking about a waiver. You're not required to take retroactive contributions from employees. So say they qualified for a waiver and they executed one and then their schedule changes and now they no longer qualify for a waiver. You can take retroactive contributions to cover the cost of having them on your policy, but you don't have to. So it is not required. Okay, next question here is the job protected if the employee needs leave beyond 12 weeks? And the answer is, the job protection, employers are prohibited from discriminating or retaliating against employees in any way because they take or request paid family leave, and they're entitled to return to the same or comparable job upon the end of their PFL leave. So time away from work after a period of PFL ends is not PFL, and it's going to be subject to your normal policies. If an employee thinks that they've been discriminated or retaliated against, they're still going to be free to file a discrimination claim if they believe that they've been discriminated against, but the employer would have a chance to show their hand, if you will, and say, no, like this person has been out for 15 weeks, so they haven't been at their job. Time away from work that is not PFL is not PFL, and it's not going to be subject. It's going to be subject to the employer's normal time off policies. Okay, next question here is, can an employee use PFL to take a parent or grandparent out of the country if they're continuing with medical treatment? And the answer is yes. So there is no requirement in the PFL law or regulations that an employee stay in the United States for family care leave or for any types of leave. The employee does have to be in close and continuing proximity to the family member, however. So like they can't just take PFL, the grandparent goes out or the parent goes out of the country for medical treatment and the employee is still just staying here at home. That wouldn't qualify. They do have to be in close and continuing proximity. But if the employee is traveling and with the family member and they're getting treatment outside of the country or they're in the hospital outside of the country, that's fine. There's no requirement that an employee be in the United States in order to take PFL. Okay, next question here is, does the agency send out the PFL rate for 2024 to send to the payroll company? So the link that I posted in the chat is where you're going to find the decision. It's posted on the Department of Financial Services website. That's the publication of the rate. It is also on the Paid Family Leave website, but I don't believe that they send out a letter or anything like that. They issue the decision and it's posted publicly for everyone to see. Okay, next question here is, can insurance carriers require employees to complete forms created by the carriers, not the template forms created by New York State? And can insurance carriers deny the template forms created by New York State? So insurance carriers have to accept the New York State paid family leave application. So like what's available on our website to apply, they have to accept that. They cannot say, no, 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 this isn't our form. You have to use our form. They have to accept the paid family leave form. They also have to, if they have their own, they are allowed to have their own application if they want, and many of them do. They just brand with, you know, whatever the carrier name is and their colors, whatever. They're allowed to do that, but they have to accept the New York State version as well. And on their version, the carrier version, they have to ask the same questions as well. So there's really no functional difference. It's just if it has the New York State branding or the carrier branding really is the difference. But they have to accept the New York State one and they cannot deny an employee because they use the New York State one. Okay, next question here is just to confirm there's no end date for the COVID-19 sick pay. That's correct. The legislation that talks about the COVID-19 quarantine leave benefits does not contain an end date, and it hasn't been repealed or sunset or anything like that. To have it end and have an end date, there would need to be a legislative amendment. So you are free to reach out to your legislative representatives if you believe that, you know, there should be either a change to the law or that it should be repealed or whatever the case may be. Your legislative representative is who to contact if you think there should be a change to the law. Okay, next question here is, when a member is out on PFL in 2023 and then the PFL goes into 2024, does their average weekly wage get adjusted to the higher amount, or do they stay at the original weekly wage from 2023? So the benefit rate in effect on the employee's first day of leave is the benefit rate that's going to be in effect for that whole entire period of paid family leave. So if they start, you know, they're taking bonding leave and they're starting in December 2023 and they're taking 12 weeks, which runs into 2024, their average weekly wage starting at the first date in December, that's going to be their benefit rate for the entire period of leave. So when you have different periods of leave, like if you take leave 2023 into 2024, it's going to be that 2023 rate. Then if 6 months later you take a little bit of time in 2024, then it'll be at the 2024 rate. But it's the benefit rate in effect on the first day of leave that governs the whole period of leave. Okay, the next question here is, how do employees qualify for a waiver? So there are two categories of employees who qualify for a waiver, and it's based on their schedule. So it's if an employee regularly works 20 or more hours per week, but they won't be in employment with that employer for 26 consecutive weeks, or if they work less than 20 hours per week, but they won't work 175 days a year. And Adam put it back on the screen for you, so you can see there if you want to copy it down. But those are the only two categories of employees who qualify for a waiver. Okay, the next question here is, if an employee takes disability following the birth of a child, can they get that benefit and then take an additional 12 weeks after their disability payment cease? So yes, there is a combined statutory maximum of 26 weeks of disability and paid family leave in a 52-week period. But generally speaking, if we're talking about the birth of a child, it's going to be 6 weeks or 8 weeks, depending on the manner of birth, unless there are complications. But generally, we're talking about 6 weeks or 8 weeks. And then, yes, if they're eligible for paid family leave, they could also take 12 weeks of paid family leave because that's not reaching that 26-week cap. So generally, yes, and this is very common. A lot of people take disability and then paid family leave immediately after upon giving birth to a child. Next question here is, I have been submitting the PFL forms to our carrier myself. Is that okay, or should I tell the employers to do it going forward? So it is the employee's responsibility. So I can't provide legal advice, so I'm not going to be able to tell you, like, guide you on your business practices, but it is the employee's responsibility to do so. So that's really kind of all I'll say on that. The next question here is, please confirm that the employee has to use all the PTO available before they can start their PFL. So that is incorrect. Employers cannot force employees to use their paid time off before they can take paid family leave. So that's just incorrect. So an employee, if they're eligible for paid family leave, they can take paid family leave. They do not have to use their paid time off. Okay, next question here is, regarding the 12 weeks of PFL, if an employee doesn't take it consecutively, do they have to take it after a certain amount of time, and can it roll over into another year? So paid family leave is based on a rolling calendar. So it's 12 weeks of leave is the maximum in a 52-week period, but that's a rolling calendar. So it's not, sometimes for FMLA, you'll see like it's January 1st to December 31st, and then it resets. That's not the case for New York State paid family leave. It's 12 weeks in any 52-week period. So if an employee takes 12 weeks of leave, then it's going to be another year before they're eligible for any more. But if they take, for example, 6 weeks in 2023, but then it's less than 52 weeks, and then they have another 6 weeks that they need to take, they can do that. It's just in any 52-week period, you can't take more than 12 weeks. So on any day that's being claimed, essentially what the carrier is doing is they're looking back 52 weeks to see how much leave the employee has taken, and that will inform how much leave is available to them. Okay, I see another question about temps getting rehired each year. And then the question is, how far do you need to consider the 175 days for the waiver? Until their most recent rehire date or forever? So eligibility for PFL and gaining eligibility only counts while you're employed with that employer. So if you work for an employer for 2 months and then quit, and then you get another few jobs and then you come back and then you're rehired, you have to start regaining eligibility again. So if an employee is being terminated and then rehired every year, the eligibility clock is going to start again, and so will the gauge of whether or not they're eligible for a waiver as well. Okay, next question here is, how long does PFL take to go into effect from the time the application is completed for the employee? So the employee submits their application to the carrier, and the carrier has 18 days from the first day of leave or receipt of a completed request, whichever is later, to either pay or make the first benefit payment. So it's 18 days from the first day of leave or receipt of the completed request, whichever is later. But the benefit payments will go back to that first day of leave. So it's just their first day of leave, the carrier needs time to process the claim. So it's 18 days from the first day of leave or receipt of the completed request, whichever is later. But the benefit payments will go back to the first day of leave. Okay, next question here is, what's the best way to refund if PFL contributions, if too many contributions were taken from an employee? So you do have to refund to the employee any excess contributions or contributions taken in error. We do not prescribe how you do that. So the PFL law and regulations don't tell you how you have to do it. And I can't provide legal advice, so I can't tell you the best way, but it's just, you just need to refund it, but we don't tell you how you have to do that. Okay, next question here is, if you take PFL intermittently within a year, if there's a gap, do you have to reapply? So if you're taking intermittent leave and the certification lasts for the year, that's fine. If there's a gap, so if there's more than 90 days between days of leave, it is considered a new claim under the law, and the employee would have to reapply in that instance. So if you are taking leave, you only need it once a week, and then there's like 4 months or 5 months where you don't need leave, and then you need it again, and even if it's for the same reason, you will likely have to reapply, because under the law, it is considered a new period of leave, a new claim, when it's separated by more than 90 days. Okay, next question here is, if a remote employee lives in another state, are they eligible for PFL when they work for a New York company? So to be eligible for New York State PFL, you have to be localized in New York State, meaning you have to work in New York State generally. If you look at Section 201 of the Workers' Compensation Law, there's kind of a long test that you can look at, which has factors and determines whether or not someone is considered localized in New York State. But generally speaking, if they do not work in New York State, they're not going to be eligible for New York State paid family leave. Okay, next question here is, if an employee becomes eligible for PFL after starting leave, are they eligible for PFL mid-leave? So if an employee is not eligible for PFL yet, they cannot take PFL. So they're not going to be able to take PFL and then have the PFL start during their leave. But if we're talking about like a leave of absence or something like that, it's possible that that could count toward eligibility, but it's also possible that it couldn't. So it's extremely fact specific. And because I can't provide legal advice, I'm not going to be able to kind of give a yes or no answer. If you look at the Paid Family Leave website, there's a lot of good information about situations like this, and there are links to the regulations. And I'll give you the main one that's going to be the most helpful is 380-2.5. So 12 NYCRR 380-2.5 is going to be the most helpful for that, but it's extremely fact specific. You can also talk to your carrier if you have specific questions. Okay, next question here is, if an employee decides to take individual days for PFL, how far in advance do they need to tell you? I have an employee who is taking bonding leave, and he knows he wants to take a whole month, but then may want different days and is not sure of the schedule. So for intermittent leave, for foreseeable leave, and for any leave, employers can require notice before each day of intermittent leave. So we're not talking about continuous, we're talking about daily increments. Employers can require notice before each day of leave. So it's as much notice as practicable. For foreseeable leave, generally we're talking 30 days notice, but it's very, very fact specific. But generally speaking, you can require notice. It's just kind of the question becomes, well, what is enough notice? And it is very fact specific. Okay, next question here is, do PFL and FMLA have to run concurrently? So they do not have to. Generally speaking, they're going to run concurrently. The statute says unless the employer expressly allows otherwise, they're going to run concurrently, but they don't have to. If you want to allow your employee to take them consecutively and to stack the leaves, you can do that if you want to. It's not required. The employer can allow the employee to take them separately if they want to. Okay, I see a follow-up here. I think that we're talking about that this employee submitted their application 30 days ago and hasn't received a decision. So you can request arbitration. All PFL claim related disputes, including untimely payment of benefits, are subject to arbitration. And Adam just put the website up on the screen for you. So it's that nyspfla.namadr.com. So that's where you're going to want to go, and you can request arbitration, and a neutral arbitrator will review and make a decision, including whether or not they have to pay interest to you for the late payment. So that is going to be your remedy for a late decision on a PFL application. Okay, next question here is, what type of proof does an employee need to take care of a family member abroad? So there's no different proof that's required for taking care of a family member abroad. There's nothing that says, here is where I'm taking it. You just have to keep in mind the PFL-4 has to be completed by an employee, the family member's healthcare provider, practicing within the scope of their practice. So that's really the only thing to keep in mind. There's nothing different that you need. You just have to make sure you're in close and continuing proximity and that you have all of the required things in the PFL-1 and PFL-3 and PFL-4 for family care leave. Okay, I think we have time for this last question here. An employee can waive the PFL, but we are required to give any employees waivers who may not qualify, such as a per diem employee. So I'm not sure I'm completely understanding your question, but if we're talking about someone who does not qualify for a waiver, you can't offer them a waiver. It's only those two categories of employees that we've talked about that are eligible for a waiver.
All right, thanks, Courtney. Yeah, it is pretty much 1 o'clock. We are going to have to wrap up. We do have a few questions that we're unable to get answered. We apologize for that. However, I am going to put up the helpline number one more time. If you want to, you can always call that to get your question looked at. Or we are going to be hosting this session again next week, next Thursday, November 2nd, at the same time, 12 o'clock. Even if you can't make it for the presentation part, just want to hop on for the Q&A session just to ask your question again, feel free to do that. Again, we are going to be providing a copy of the slide deck and a recorded version. We will email you when those are available. But for now, I want to thank you all for joining us, and thank you to Courtney for taking the time to answer all your questions today. We had a lot of questions. We always appreciate your participation, and I always appreciate Courtney coming on with us to answer your questions. And you can sign up to receive paid family leave news, including information on future webinars, straight to your inbox. To sign up, just visit the Paid Family Leave website, scroll down to the bottom of the homepage and select Get Updates. And we do also distribute information via social media, so make sure you're following the Workers' Compensation Board on Facebook, X, Instagram, and YouTube. That YouTube page, as I had mentioned, we do have previously recorded versions of PFL webinars on there as well. So if you need a refresher at any point, feel free to hop on there, search for Paid Family Leave webinars, and we have a plethora of them up there for you. All right, again, thank you all for joining us, and please enjoy the rest of your afternoon. Thank you.